So one of the themes that keeps coming up in many of the different firesides and panels today is regulation. So that is what the next panel is about, and I'm going to let our moderator, Michelle Gitlitz, take it away.
So good afternoon, everyone. Thank you so much. I'm Michelle Gitlitz. I'm the co-chair of Blank Rome's Blockchain and Digital Currency Group, and I'm really thrilled to be here today. Josh Clayman is on her way. She will be here. I'm here with Joel Telper, Jake Travinsky, and Mason Borda, and I'm going to let them all introduce themselves. We have a really exciting panel. There's lots going on in the crypto and blockchain space, lots of regulation to talk about. We encourage questions. We don't want to talk at you, so please feel free to raise your hand and ask some questions. And I'll let Joel give a little bit of his bio before we start.
Sure, thank you. I head the blockchain and fintech practice at Sullivan & Worcester, and I got involved in this space in 2014 by accident, when I was hired at my former firm by Overstock to help them become the first company to issue a security on the blockchain. So if you guys like the STO market, I take credit for it, rightly or wrongly. If you dislike the STO market, it's not my fault.
Hi everyone, I'm Jake Travinsky. I am formerly of the law firm Cobray & Kim, where I did securities litigation and government enforcement defense in the firm's cryptocurrency practice. I will actually be starting a new job in about 2 weeks, but we're all going to have to wait for the announcement on that one, so that's all I'll say there.
My name is Mason. I'm with a technology company called TokenSoft. So we're a technology and security platform that helps issuers of digital assets issue these assets on the blockchain while remaining in compliance with applicable banking, securities, and tax regulations. We do that either domestically, or we also have clients that we're helping comply in 56 jurisdictions around the world when it comes to securities laws.
And Josh was able to make it, so we'll let her introduce herself.
Hi, I'm Josh Clayman. I'm founder and CEO of Clayman LLC, which is a boutique blockchain-focused law firm, and also Inflection Point Blockchain Advisors, which is a consulting firm. I also chair the legal working group of the Wall Street Blockchain Alliance, and with Michelle, I'm a co-founder of Diversity in Blockchain.
And Diversity in Blockchain is really excited to be partnering for this summit. So we're going to talk a lot about security tokens today because there's been a lot of regulatory action in the market. And Mason, can you give us a brief overview of what security tokens are and kind of explain to us what the evolution from ICOs or initial coin offerings, can you walk us through that?
Yeah, so all of this technology sort of starts with developers experimenting with some new tech that they've built, and that's how Bitcoin came about. Someone just put the software out there and it proliferated out there in the world. And with security tokens, the genesis of this was developers in online communities trying to figure out how to fundraise for their projects without having to go out there in the world, and so they could stay behind their computer and do so. And so basically what these companies were doing was they would put a cryptocurrency address on a website, announce what they were doing, and if people were interested, they would help put money into these projects. And so this started to take off very informally from about 2014-ish through 2017 when it really took off. It turns out that when people started consulting law firms to do these types of fundraisers, they were securities offerings. And so that started to sort of become the consensus with major law firms around summer of 2017. And so people started doing these fundraisers under securities laws on the blockchain and issuing their own assets on the blockchain. As more and more people started to look at the space, they started to say, hey, what if we fundraise either with fiat currencies or cryptocurrencies and issue a token that is backed by an asset? And so starting in 2017, we had clients that were looking at tokenizing equity. We had a fund of funds, late-stage venture fund, that was looking to have their LP interest in their fund, for example, be represented on the blockchain. And so now this is starting to become more of a formal area, and we're seeing institutions take a look at it. We're seeing mainstream businesses take a look at it as well, just like Overstock, like you mentioned. And it's now becoming more of a formal space.
So Mason, you just mentioned that you're seeing institutional investments and business investments. Are security tokens an asset class that both retail and institutional investors can participate in?
Yeah, I mean, the way I would think about them is essentially the existing financial infrastructure is very mature, and securities get issued all the time. And what's happening is that financial infrastructure is simply being rebuilt on the blockchain from the ground up. So a lot of the things that people are doing traditionally in finance is simply being ported over. So I think we're going to see more and more traditional asset classes just simply be ported over and be built on top of new technology.
Great. And are security tokens issued subject to certain restrictions? And if so, can you discuss some of the pain points with respect to those restrictions?
Yeah. So we see transfer restrictions primarily in relation to the securities laws that apply to these securities as they transfer around the world. The most common one that we're asked to enforce is Reg S, Reg D flowback. So if you do a Reg D sale concurrently with a Reg S sale, the Reg S token, based on the guidance of counsel, can get distributed earlier. For the US, there's generally a 1-year lockup period. And so some of the things that we're sort of asked to do are to enforce on the blockchain that tokens from outside of the US can't transfer to people inside of the US. So those are some of the technical sort of restrictions that we're enforcing on the blockchain with smart contracts.
And how exactly are you enforcing those restrictions?
Yeah. So our platform, when people onboard onto their platform, whether they're an individual or an entity, we're collecting their identity information since they're going through KYC. So we know who everyone involved with this issuance is, and we know the identities of all the people that are also holding the token. And likewise, we're filtering for what jurisdiction they're coming from. And so we can filter US participants from non-US participants. And now once we have them in the door, we can also link a blockchain address to their identity. So now we have 2 lists of identities and blockchain addresses, and we know which ones are US and non-US. So in the smart contract, in the blockchain, we can basically enforce that these addresses are US addresses, and these other addresses are non-US addresses, and we can make sure that they don't intermingle. They don't transfer the security across these 2 different lists. So it's just how our technology is architected, and we've been able to enforce some of these complex and nuanced regulations.
And so I think you just focused on the Reg S restriction. With respect to the Reg D restriction and any required holding period, how do you enforce that restriction?
Okay. So now we're getting pretty technical. So there's 2 ways to enforce that restriction. So one thing that we commonly see is that the sale happens, the sale closes and ends, and the investors simply do not get tokens until the 1-year lockup is done. So the tokens just don't exist. The other thing that you can do if you want to be more fancy is we don't do this, is send the token to the individual investors and then just not put them on a list, not enable them to transfer. And so the legal interpretation that would require that would be if it was required that the investor actually have custody of the token during the lockup period. So that's a different interpretation. We don't see it as commonly, but it's also possible.
So let's talk a little bit about regulation. Joel, the SEC recently issued a statement on framework for investment contract analysis of digital assets. Could you tell us a little bit about what we'll refer to as the framework?
Sure. So the framework came out a couple of weeks ago, And it was an attempt by the SEC to provide guidance on their view as to how they look at security tokens, specifically those tokens that the SEC deems to be a security because they fall within the category of what's called an investment contract, which people have heard us talk about as lawyers many times when we go through the so-called Howey test. The framework probably for the most part, at least in my view, didn't really give us much new. What it really did was consolidate what the SEC has been saying for a while now. So it was a consolidation of the view expressed originally in the Dow report that came out a long time ago, their Munchie and some of the other enforcement orders, and also reflected a speech, the outcome of a speech given by Bill Hinman, the director of the Division of Corporation Finance, just about a year ago. And so for the most part, the framework talks about how the SEC has already been thinking about investment contracts in tokens to date. So the takeaways are that they continue to express a view that, at least from their perspective, that many, if not most of the tokens that are issued in the forms that we've seen to date are probably investment contracts and therefore securities. They reiterated the notion that was expressed by Bill Hinman in his speech last year that even though a token may start out as a security, it is feasible that at some later point in time, that token is either no longer going to continue to be treated as a security, so that it either morphs into something that's no longer a security, or at least the SEC it feels that at some point in time it's possible to discontinue applying security law sales restrictions to those tokens. They left really, in many ways, unanswered the question of how we get from something that might be a security at one point in time to something that's no longer treated as security. So the evolution of that token, what it takes to go from potentially a centralized to decentralized type of structure in order to change the treatment of the token is still ambiguous. And in fact, many of the lawyers looking at the framework think that maybe they made the situation actually worse instead of better because they introduced some new concepts into the analysis, in particular a concept of what's called an active participant. And basically what the SEC has said, or the staff said in this, was that if there is a person, a combination of people, an entity, or a sponsor, somebody that is responsible for that token or involved in that token, that entity or person would be deemed to be an active participant. And if an active participant is playing a so-called essential role to the success of that project, that would indicate that you've still got an enterprise where people are investing on a collective basis, and therefore it's likely that under the so-called Howey test, there would be an investment contract. So by introducing this new concept of active participant, they in part were perhaps trying to help us decide when we went from centralized to maybe decentralized. But what they really did was force us now as lawyers to have to look at, is there an active participant? Who's the active participant? Are they operating with respect to an enterprise? So what's the enterprise? Is the function they're performing an essential one? And is that essential function directly tied to the future success of those activities? So we now have, in effect, a number of additional, in my view, subjective tests that we as lawyers and we in the market have to deal with in order to determine whether or not we're dealing with a token that's either a security because of an investment contract or something else. Now, the last thing I'll mention on this, and then I know Josh will probably also have a lot to say on it, is that they didn't say that every single token is automatically a security, but they said, presumptively a lot of them are. But they did recognize, for example, the way that we can look at the consumptive nature of tokens as a potential distinguishing factor for a smaller subset of tokens that may not appropriately be deemed to be a security. And among those things, they mentioned in particular virtual currencies. Now, while they failed to define what they mean by virtual currency, they acknowledge that there at least is, for example, a category of coin that's a virtual currency that is intended to be a store of value, that's intended to be used as a form of payment, and where you've got a situation where that virtual currency is introduced, can immediately be used as a form of payment, that would be potentially an example of a token that would not fall within the definition of investment contract. They also, lastly, talked about some other issues that are important for people to talk about, in particular in the context of airdrops and other types of barter arrangements, reminding us that to the extent that we're dealing with the security, you can't avoid security law treatment if you're simply doing something like an airdrop, because the SEC takes the view that in those scenarios, people are usually receiving an airdrop, a token in an airdrop in exchange for providing some type of service to the company, whether it be marketing services, consulting services, or something else. So in many cases, even if you're not specifically selling the token, but you're so-called giving it away, it still may be deemed to be a sale for purposes of security laws. And if that token is otherwise an investment contract, then the distribution via an airdrop or some other similar arrangement would also constitute a transaction in security. So that's kind of where we are as a result of the framework.
Great. Josh, you're the chair of the Wall Street Blockchain Alliance Legal Working Group. What's the WSBA's view on the SEC's framework?
Thanks, Michelle. So I'm going to be looking very closely at Ron Quaranta, who's sitting in the front row, who's the founder and CEO of the WSBA, in case he starts shaking his head vigorously that I shouldn't be saying something. But the WSBA's view, let me first say, not legal advice. Nothing any of us is saying is legal advice or investment advice. And also, there are many lawyers within the WSBA Legal Working Group, so it's not a monolithic view necessarily. With that being said, I think some of the things that we've discussed and that we'll be putting out in a more formal way very shortly, I can perhaps touch on. And some of the lawyers on the stage here have been instrumental in helping put it together. So this isn't all coming from my brain. So building on what Joel said, one of the key things that in our view, and I'll say our, just knowing it's maybe not every single person on the WSBA Legal Working Group, is that the new guidance doesn't really change typically the advice that we may give to a client, which is that absent guidance to the contrary, particularly for an initial sale of a digital asset for fundraising purposes to US persons, you should start with the assumption that it is very likely going to be a sale of securities, right? Nothing in the framework changed that. In fact, we've been seeing from the Dow guidance to Munchie, all of this guidance down the line, a narrowing of what may be a sale of a digital asset that would not be the sale of a security. And actually, the framework deals with all transactions in digital assets, not just offers and sales. So it's important to remember that. So that's point one, which is likely doesn't change our advice. Likely is a small, narrow window through which one would be able to do a sale to US persons for fundraising purposes that would not be the sale of a security. A few other things, and Joel touched on some of them, but I'm going to try and cover some of perhaps the others. So, for example, one of the things that the SEC staff did in its framework, and we should say it was the staff, it was FinHub's guidance, it's not the word of the SEC, it's not binding, it's just kind of like if people had given a speech, it's similar, and it supplements but doesn't replace prior guidance. So a couple of the things that they said that we thought were kind of interesting, one was they said you should generally assume, and let me just for 1 second run through the Howey test. Many of you I'm sure are fatigued by it, but just in case some don't know, it'll be relevant to this. It's whether there's an investment of money in a common enterprise with a reasonable expectation of profit based solely or primarily on the managerial or entrepreneurial efforts of others. So the staff said you typically are going to find prongs 1 and 2 satisfied. There's typically going to be an investment of money, and there's typically going to be a common enterprise. Now, different circuits are split as to the question of what constitutes a common enterprise. There's vertical enterprise, there's horizontal, but the SEC is saying it's generally going to be there. Now, we're not so certain that we should just assume that it's there, right? Another thing is the investment of money piece, and this touches upon what Joel had said with airdrops. So one thing just to touch on, since he covered that quite nicely, is we think it's important not to collapse the inquiry of whether first you have an investment contract, right? You have a security first, and then whether the gift of that security is actually a sale. And it's a very low bar, by the way, for whether a gift is a sale. It's just whether the recipient receives some kind of benefit, right? And it could be just the benefit, the creation of a public market. But the collapse of those two, we don't think should be made into one inquiry. So the question of whether there's been an investment of money perhaps needs to be decided in determining whether there's a security. If it's an investment contract or some other kind of security, it could be equity linked. And even some may say, well, what about Tomahawk? Well, some may remember that Tomahawk was an equity linked token, right? So it wasn't, in some ways, it was quite different from a token that may not be equity linked. And this leads me to the next point, which is one of the things that we think is a key thing that needs to be addressed is whether these digital assets that may be sales of securities that we've been testing with the Howey test to see if they're investment contracts, are these necessarily equity securities? Now, some of you may say, why does this matter? Well, if you have heard of the AirFox, Paragon, and Gladius network cease and desist orders, in those cease and desist orders, those enforcement actions, basically those token sellers who had sold tokens, the SEC said, look, these were illegal sales of securities. And what is the path forward? You're going to register your tokens, your digital assets, as a class of equity securities under Section 12G of the Exchange Act. Well, 12G applies to equity securities. And the question of whether every investment contract is going to satisfy the definition of equity securities, that's something that we think you need to assess on a case-by-case basis.
Right. In fact, in those enforcement actions, the SEC reached their conclusion on the basis that they were investment contracts, but then went on to treat them as if they were equity securities.
Right, so some of the things, and I'm not going to belabor this because I could go on forever, and there will be written guidance about this, or written, not guidance, written response about this. But one of the interesting things is, if you look at Blockstack's Reg A filing, Reg A plus filing, they take the position that that was not an equity security. And so what falls away if it's not? Well, you don't have to worry about 12G, and you don't have to worry about, for example, transfer agents, things like that. So there are a lot of things that we think you need to delve into further. So that was my long-winded way of giving a preview of what is to come.
No, thank you. I think that was excellent, and I think when you read the guidance, you may not always appreciate all the nuances. And what's really important about working groups like the Wall Street Blockchain Alliance and the other working groups that are out there are the need for us as practitioners and for those in the market who are issuing securities, who are investing in tokens or digital assets, to participate in the dialogue. And that's what's really important about these conferences, is to enhance that dialogue. On the same day that the SEC issued, that FinHub issued its statement on digital assets, the framework, they also published the turnkey no action letter. And I wanted to turn to Jake to get some color on that no action letter.
Yeah, so let me tell you a little bit about the no action letter that came out with the guidance. I'll preface this by saying I am one of the lawyers who is not very impressed or very satisfied with the framework itself, and I'll throw in a couple words about why I felt that way as well. But the no action letter was a message from the SEC that, as the name states, they won't take any action against Turnkey Jet, which was a company that wanted to issue this token, the TKJ token. And the description of the token by the time the SEC agreed that they wouldn't take any action was basically not a cryptocurrency or a digital token in the sense that we think about it at all. It was more or less a reward point system where the token was one-to-one pegged to the dollar because the company would only take back the tokens in the value of $1 per token for services that they would provide in chartering jets. They had a system where the tokens were not going to be traded on any kind of exchange. They couldn't be transferred between individual people, so there wasn't really any market created around them at all. And so the SEC said, we won't take any action against this type of token. I think there's two ways of looking at what the SEC was saying with that letter. I think there's an optimistic view and a more pessimistic view, which is probably the one that I take. I think the optimistic view is to say the SEC is making a really serious effort to send the message to all of us that they're not trying to kill this industry. They are willing to work with us, and they're willing to give us some guidance in terms of what we can do without getting in trouble with them. So I think that's sort of the optimistic message, that we finally got one of these no action letters, and that's a positive development. I think, on the other hand, the pessimistic view is to say the SEC will only produce a no action letter for a token that doesn't represent any of the interesting things that this space is developing. And if you want to get that no action letter, you basically have to cheapen the product that you're trying to launch so much that there isn't really a point to doing it at all. So, I think some of the background for that is also helpful to know, which is that before Turnkey Jet got that no action letter, apparently they had dozens of meetings with the SEC over a period of, I think, 11 months. And the initial proposal that they sent to the SEC didn't resemble what ended up getting the no action letter at all. So the SEC backed them down from the token they actually wanted to launch until they had this really watered down version that finally qualified for the no action letter. So take it as you will. If I can throw in a couple words on the framework. So my take on the framework was that, as my fellow panelists mentioned, it didn't really tell us anything new. It didn't tell us securities lawyers anything about the Howey test or its application to digital tokens that we didn't know already. What it did, in my mind, is confuse how the SEC is going to approach enforcement in this space. So if you step back and look at this from a big picture view, what we want from the SEC is regulatory clarity. We want to know in advance, if we launch a token, what are they going to say about it, and are they going to come after us for having launched it the way that we did? I don't think that this framework helps us to make that determination at all, and there are a couple reasons why. I think the main reason is we got 11 pages of potential factors that the SEC says might turn a token into a security, but they didn't tell us which of the factors were most important in their mind. They didn't tell us if there were other factors that they might consider outside of this list, since it was a non-exhaustive list. And they didn't tell us how many of the boxes one could check when launching a token before it becomes a security. And without providing some guidance in terms of what factors actually matter and which ones don't, it's really hard to give advice about what kind of project you can actually launch. And to me, the biggest problem is this airdrop issue, where in my mind, when you're looking at the Howey test, as Josh just said, the very first element is an investment of money. An airdrop, almost by definition, has no investment of money, which means to me, by definition, an airdrop should not be treated as a security, except in those sort of specific circumstances where you're giving back something of value, maybe you're marketing for the token, or you're creating a secondary market or something of that nature. But for the SEC's entire treatment of airdrops to say, well, airdrops might still be securities based on facts and circumstances, and we're not going to give you any more guidance about when they are or when they aren't, really isn't helpful to this industry, and that's why I frankly wasn't very happy about the guidance.
So the one thing that we also wanted to cover was we're really focused on security tokens and the SEC, but one thing to note is there's a lot of authorities that do regulate digital assets. And in particular, last week FinCEN published its guidance, which again was, I'm going to let Jake talk about, was nothing new, but just to give a little bit of framework, money transmission is a major issue with respect to digital assets. And on the federal level, the federal government is worried about anti-money laundering, financing terrorism, and on the state level, every state except for one has its own money transmission laws that are enacted to protect consumers. And so when you're dealing with digital assets, you have to be focusing on so many different regulatory issues that sometimes it's a bit of I like to call it an alphabet soup landmine, because you have to deal with all the different government regulators in all the different jurisdictions. But Jake, maybe you can give us a little bit of color on what FinCEN published last week.
Yeah, so FinCEN put out a guidance last week explaining which entities operating in the crypto space need to register as money services businesses under the Bank Secrecy Act, which means you have to set up a whole anti-money laundering compliance program, fairly onerous requirements. You need internal controls and a training program and a dedicated compliance officer and customer due diligence and all of these things that in theory, a crypto network shouldn't have to do. And so FinCEN gave some guidance about what factors make someone regulated as a money transmitter under the law. A money transmitter is basically defined as someone who receives or accepts money or anything that substitutes for currency and then transmits it to another person or to another location. And if you do that, you're a money transmitter, you have to register, you have to set up this whole anti-money laundering compliance program.
Jake,
yes.
Can I just, I always find that people get a little fumbled by the transfer to another person or another location. So when you talk about a transfer to another person, that's really easy to understand from me to Josh. But a transfer to another location could be from my account at place A to me at a different account location, place B.
Right, exactly. So it might not be a physical location that it's being transferred to. There's also a theory that FinCEN has put forward that transferring to another time, basically if you give money to someone and they hold it for you and then send it back to the same person and the same account, might be money transmission as well. So this does get kind of confusing. I won't bore you guys with all the specifics of what the guidance said, but I think the gist of the guidance was FinCEN understands that in terms of a crypto network, often the industry is creating smart contracts or other platforms where the company itself does not have control over the user's funds, which is very different from traditional payment processors or banks where you entrust the entity with custody over your funds. And what FinCEN basically said in the guidance is, if the company is not in control of the funds, then the company is not a money transmitter under the law. And there was some gray area around more interesting border issues like decentralized applications and the developers of those applications and providers of anonymizing services and things like that. But overall, I actually thought it was a really strong guidance, really for the reason that I thought the SEC's framework wasn't that helpful. FinCEN is willing to say when they don't have jurisdiction over certain actors in this space, they're willing to say, here are the people who do not have to register as money transmitters, whereas I feel like with the SEC, all the SEC is willing to do is say, here's how far our jurisdiction extends, this is what we're certain of, maybe it extends further, we're not really gonna tell you, and they never explain when someone is really exempt from the securities laws. So I applaud FinCEN for being so frank and straightforward in that sense.
So we have about 8 minutes left on the panel, and we'd love to open it up for everybody's questions and impressions. Yes.
Are utility tokens dead?
Are utility tokens dead? I personally don't think that utility tokens are dead. I think there are many different types of tokens. I think there's security tokens. I think there's debt tokens. I think there's asset-backed tokens. I think there's reward tokens. I like to say a token is not a token is not a token. So you can't just call something a token. You have to modify it. But I'll puck it to the rest of the panel.
I don't think they're dead. I think it goes back to what the SEC had previously said, that there's a distinction between if you're selling a token for purposes of raising capital and the project that you're raising capital for doesn't yet exist and people are buying the tokens and have to hold it and depend on you to complete the project, that's the classic definition under the Howey test of an investment contract, because you're in effect speculating, hoping that a management team or developer is going to build this project, and that as a result, your token is likely to go up in value by the time that project's done. But if you're out there with an operating platform in a business and you are now creating a token that may be critical to accessing goods or services or to making that business function, and you're selling the token in that context as opposed to for purposes of capital raising, I think that there's still room for those tokens to go into the market without them being treated as securities.
I think that's probably one of the reasons FinCEN put out new guidance, is because initially when FinCEN was really active, 2013 to 2014, people just had digital assets and wallets and exchanges, and it was that simple. But the technology really evolved in the last 2 years, and so now we have things like Lightning Network. There's all these DeFi apps. People are trying to do loans, stable coins that are algorithmically backed or collateralized. And the fact of the matter is, these aren't all securities, but if they're not, what are they? And from my perspective, there's a big hole in the space where, okay, if it's not a security, then what is it? And if you ask me personally, I would have always said, well, it has to be treated as a currency. And so I think that's what's great about FinCEN coming back into the space and taking a second look, is because there's all these different technologies, and if you look at the guidance, there's literally, I think, 10 plus different types of technologies on the blockchain that they've sort of outlined. And so are they dead? No, but they're probably currencies regulated under FinCEN.
And I mean, if I could just chime in, I think a couple of things. One, it depends on where you are, right? The rest of the world has them, or many of the other countries have them, right? And in Wyoming, there's still the concept of them, certain other states. I do think, though, that the froth from 2017, in particular, in the beginning of perhaps 2018, I think that put a dark color on the word utility token. I think focusing on a token's consumptive use is probably a little bit more palatable. I do think, though, one of the things, if I'm going to be an optimist to Jake's pessimist about some of the guidance, I think with the no action letter, at least we know that, look, there's a centralized issuer, right? No decentralization there. It's centralized. You may never want to use that as your model, or you may never want to use a blockchain for it, right? Like, it may be completely not something you would ever do, but at least it is not decentralized. So it gets us away from the idea that everything has to be decentralized. I really do think that after the DAO guidance, when everyone came out and they were just saying, my token is non-incidental utility, I have a utility token, but they were selling it, as an investment and going on, YouTube channels and things like that. I think that has gotten things way out of whack. So I think we're on our way back.
Okay, so your client comes up to you, and I'm over here. Your client comes up to you and says, Binance or Bitfinex or IDEX is telling me to do an IEO. I can get $50 million right now in 12 minutes. You know that it's not going to work for US purposes. How do you advise them?
Don't sell to US persons.
And what in terms of controlling transferability, everything else?
Well, I think that's part of what Mason was talking about. And we have to remember that the onus is on the issuer. And the issuer can't really place that onus on the investor. That just doesn't work. The SEC doesn't agree with that. So you need to make sure that there's some mechanism by which you can either block U.S. investors or make sure that a consultant or a company or somebody else is helping you program that token in order for it not to get into the hands of a U.S. purchaser.
And by the way, embedded in your question is the concept that if the SEC deems what you're selling to be a security, whether it's an investment contract or equity security, doing it through an exchange like that, from their view, would simply mean that that exchange needs to be regulated and registered as a broker-dealer.
Exactly. Probably Mason, you know more than all of us, but I imagine you could program the smart contract to require some kind of verification so that before I send it to Michelle or Joel, they have to prove that they're not a US person. Not fun, but.
Yeah, exactly. Yeah, so if we were asked to do something like that, we would probably have a US front door with a US, the same asset, but users that were scoped to the US, users that were scoped non-US, and then users that were scoped just to the exchange. The problem is, how do you get the exchange to manage the regulations in their platform? And another good point was brought up, does that exchange need to be a broker-dealer? And that depends on what jurisdiction they're in and so on and so forth. So I think it's definitely making things a lot more complicated. And I think on our end, I think this is probably going to evolve and mature over the next year. It always takes a little bit of mileage and precedence to sort of see how these things sort out.
I think we have time for one last question.
Yeah, Josh, you mentioned Wyoming, and I just wondered if you could simply explain state law versus federal law. How do you think this will play out? And anyone else can comment on that as well.
Okay, I'm not a Wyoming lawyer. As some of you may know, Wyoming has been very forward in terms of trying to develop laws that, among other things, House Bill 62, what used to be House Bill 70, is their utility token bill. And it's the idea that if you have a consumptive token and it's never been sold for investment purposes, that in fact, it is not a security, it's property. And Wyoming takes the position that, okay, as to securities laws, federal law governs, right? But as to property has always been the purview of the states. So their position is that since it's, in their view, these specific types of tokens are a new form of property, that they should have the right to determine how it's treated. There are other laws that they've passed as well, and I will say House Bill 62, which was House Bill 70, was loosely based off of FINMA's framework. And we're starting to see around the world, like with the UK, with the FCA, dividing tokens into different categories. That's definitely a different approach. I guess, some of the things, just let me finish the sentence and then, but some of the, sorry about that, as you asked about the future of this, well, I think it remains to be seen because with some of the bills that have been introduced in the House, representatives, like the Token Taxonomy Act and the Digital Taxonomy Act. I mean, who knows how those will proceed, whether they will proceed, in what form they'll proceed, but right now they contain a broad federal preemption, which is kind of controversial in this space.
So let me just repeat the question. The comment was that Wyoming's passed 12 bills, and inclusive in there is the concept of creating a regulatory sandbox. And I think Josh has asked a comment on her view of the Wyoming legislation.
I mean, I think what Caitlin Long and Tyler Lindholm and others in Wyoming have done, the Wyoming Blockchain Coalition, is really amazing in terms of providing a model, whether you like it or not. I mean, some have called the states the living laboratories of democracy or the living labs of the law. And so I definitely think, I mean, look at the framework. It talks about consumptive use, consumptive purpose. I do think that there is some effect that just a lot of these laws are having more generally. But as far as how it proceeds, your guess is as good as mine.
Well, thank you all so much. We're out of time, but we really appreciate the opportunity, and I think I speak for all of us when we say, please reach out. We'd love to connect. We'd love to communicate. We're all very passionate about this space and moving the ball forward, and thank you very much.